All right, the second part of Unit 2.3 is going to cover the executive or the judicial branch. Judicial branch is presented in Article 3 of the U.S. Constitution. Now, the very basics, there's two different court systems in the United States. Each state has its own government, and in that government, they have their own court system. So each state has their own court system, along with the Supreme Court. Like there's the Supreme Court of Illinois. And then there's a federal system. The federal court system is put in place by the federal government, which encompasses all 50 states, with the highest court in the land being the Supreme Court of the United States. So the highest court in the land is the U.S. Supreme Court. All other federal courts are called inferior courts or lower federal courts. There's two types of courts. There's constitutional courts, which hold federal cases, and then you have special courts, which focus on special courts are like created by Congress to focus on specific issues, territory disputes, tax disputes, things like that. Now, the judicial branch, its main power is to interpret laws. They say if there's any conflict over whether you broke a law or not, the judicial branch interprets whether you did or not. They say this is what the law really means. And then they also settle disputes that arise in society that there aren't necessarily laws for. The U.S. Supreme Court, its major power is probably the most powerful power, the most significant power in the government. It's called judicial review. This determines if actions by Congress or the president are allowed by the Constitution. This gets established early on in a Supreme Court case called Marbury versus Madison. I'll talk a little bit about that a little bit later on. Now, the qualifications for being a federal judge, unlike the being a president or being a senator or being a member of the House of Representatives, qualifications for being a federal judge are none. They just have to be approved by the Senate. That's it. You don't have to be over a certain age. You don't have to be a U.S. citizen, anything like that. However, there are informal qualifications, just kind of things that all judges generally have. They're lawyers or they're somehow trained in the law. They're professors, congressmen. They have experience in government. And then usually they're picked for political reasons. And so you'll have Democratic presidents will choose liberal judges with a liberal political view. And Republicans will generally pick judges that have a conservative political view. Now, in the national court system, the Supreme Court, there's only one court. There are 9 judges on it. Their term is life. You get appointed to the Supreme Court, that's your job for the rest of your life. You have district courts. You have 94 of them. There are 677 judges, and you get appointed for life. Court of Appeals, you're appointed for life. Court of Appeals Federal Circuit, you're appointed for life. International Trade Court, you're appointed for life. Then you get into a little bit lower courts. You get Court of Appeals Armed Forces, you get 15 years. Tax Court, 15 years. Federal Claims, 15 years. Veteran Claims, you get 15 years. These are the sitting Supreme Court justices. You have Clarence Thomas, Sonia Sotomayor. Now, Scalia just passed away recently, and so President Obama is going to choose a new Supreme Court justice for him. It's actually under some contention right now. Beaver, Roberts, Alito, Anthony Kennedy, Elena Kagan is the newest member of the Supreme Court, and then Ruth Ginsburg. Now, there are two types of court cases. One, there's criminal court. This is where it's people versus the government, or the government versus a specific individual. They have to be convicted without reasonable doubt, so they have to meet that standard. And court sentences the people to either pay money or spend time in jail, or can even be sentenced to death. Now, these are people who break laws, okay? Now, when you have two people who are in a conflict, like, hey, this person didn't, has been paying me $25 less a month every month for the last 5 years, and I'm going to sue him, then you go to something called civil court. Civil court requires a lot less evidence, but they can only reward money. Now, each lawsuit or criminal indictment is set underneath a certain jurisdiction. The jurisdiction decides what court that particular case is heard in, whether it's state or federal court. Remember, what type of cases does the U.S. Supreme Court hear? They hear those that deal with the U.S. Constitution. Supreme Court doesn't convict people of murder or anything. They decide whether something is constitutional or not. That's their job. They hear something and decide whether it goes against the Constitution or with the Constitution. In addition to courts, in addition to cases where the constitutionality of a law is in question, Supreme Court cases, the Supreme Court will sometimes hear cases where the state is a party, like the state is being sued by another state or something, or if ambassadors or other public ministers are being affected by it. But that's kind of rare. Now, regardless of their political affiliations, judges are expected to act on how they interpret the U.S. Constitution. And it has to be a fair, unbiased interpretation of the law. What they do is they set, when they make a decision on a case, they set a precedent. Precedents are then used in other cases that are similar, being like, well, in Marbury versus Madison, the Supreme Court said, no, we only focus on determining the constitutionality of laws. So anytime the constitutionality of a law comes into question, the Supreme Court gets that case. So that means similar cases will refer to that judgment, that hearing. Here we have a few. Marbury versus Madison is a really famous one because we didn't know what it established just judicial review. What it did is Madison brought it to the Supreme Court, and the Supreme Court was like, we don't judge court cases. What we do is we determine whether a court or a law is constitutional or not, which establishes judicial review. Givens versus Ogden, this established federal jurisdiction between states. That means each state, if they're not getting along, then the federal government says, hey, interstate commerce, that's our our thing. We get to control that. We get to say what's legal and what's not legal. Sheldon versus Sill ruled that Congress cannot restrict the cases the U.S. Supreme Court can hear. These are the main cases that established the U.S. Supreme Court as independent and the highest court in the land and being able to rule on any constitutional matter. Now, just a quick recap. The judicial branch's checks and balance, their check on the executive branch and the legislative branch is that they can rule their actions unconstitutional. And by ruling it unconstitutional, they get rid of it. They just destroy whole laws. Like if they took marijuana to the Supreme Court and somebody was arguing that that marijuana being illegal is unconstitutional, and the Supreme Court said, you know what, you're right, then that entire law gets thrown out. And that'll wrap us up.